626! That's the number I want you to hold in your mind. Not a century, not a reign, a single year. The year a council of bishops convened in a provincial cathedral in what is now southern France and ratified in the 17th canon of their published acta, a clause of 73 Latin words. That clause has never been formally repealed by any successor body, has been cited in legal proceedings as recently as the 19th century, and has, in every documented instance of its invocation, resulted in the disappearance of a name from a register that the invoking authority controlled. I wasn't looking for Tartaria when I found that canon. I was researching something else entirely, the history of marriage dispensation in the early medieval church, a narrow technical question about ecclesiastical procedure. Then I found a footnote in a 1908 monograph by a German canon law scholar named Heinrich Vossberg, and the footnote referred in passing to Canon 17 of the Council of 626 as the instrument by which the Church reserved to itself the authority to declare a bloodline extinct, not deceased, not deposed, extinct, as a legal status, as a category in a register. I had never heard of Canon 17. I have a graduate degree in this field. I had never heard of Canon 17. Let me be clear about what we are told happened. The transmission of legal authority over noble bloodlines, we are told, was a matter of public record. Where dynasties ended, they ended through documented succession crises, through wars of succession, through formal acts of attainder ratified in named parliaments by named monarchs in named years. The end of any royal house, we are told, was a matter for chroniclers, for heraldic registries, for the genealogical compendia that European publishers issued in expensive folio editions throughout the early modern period. Where a line failed, the failure was published. Where a line was extinguished, the extinguishment was named. That is the official explanation. Public, auditable, heraldic. Except Canon 17, in its own 73 words, does not require any of that. The canon authorizes a specifically constituted ecclesiastical tribunal, sitting under conditions the canon itself defines, to issue a determination. The canon uses the Latin phrase determinatio extinctionis, the determination of extinction, concerning any baptized lineage whose continued recognition the tribunal finds to be, in the canon's exact phrasing, contra ordinem rei publicae Christianae, that is, against the order of the Christian commonwealth. That phrase does more work than any phrase of 73 Latin words should be permitted to do. Against the order of the Christian commonwealth is not a defined legal standard. It is not a doctrinal threshold. It is a discretion. The canon hands the tribunal a discretion and instructs the tribunal to record its determination in a manner the canon describes only as decently, discreetly, with appropriate restraint. The canon does not require publication. It does not require notification of the affected parties. It does not require the determination to be entered into any register that is accessible to anyone outside the tribunal itself. A bloodline could be declared extinct in the year 626 by a tribunal whose composition the canon specifies, on a standard the canon does not define, recorded in a manner the canon describes only as decently. I read the canon in the original Latin. I read it 3 times. I read Vossberg's 1908 commentary on it, which devotes 1 paragraph to Canon 17 and then moves on to Canon 18, which concerns the proper liturgical vestments for processions on the Feast of the Assumption. Vossberg's paragraph contains a single sentence that I have been turning over in my mind for 9 months. The sentence reads in his German, "The application of Canon 17 in the centuries that followed its adoption was extensive and was concentrated in a manner that resists ordinary historical explanation. In territories whose subsequent disappearance from the political map of Europe coincides with periods of the canon's most active invocation. Vossberg published that sentence in 1908. He did not publish another book on canon law. His monograph, according to the catalog of the university library that holds his papers, was reviewed exactly twice in the academic press of his lifetime. Both reviews appeared in 1909, and both reviews discussed canons 1 through 16 and canons 18 through 40, without, in either case, mentioning canon 17. I have read both reviews. The omission is not the kind of omission that occurs by chance. Both reviews discuss the canons in numbered sequence. Both reviews skip from 16 to 18. You do not skip a canon in a numbered sequence in an academic review of an entire monograph unless you have been advised that the canon in question is not to be discussed in the academic press of 1909. I want to stay with that for a moment. Two reviewers in two different journals, in two different German cities, in the same year, independently produced reviews of the same monograph that omit the same canon in the same numbered sequence. Either both reviewers independently and silently decided that canon 17 was uninteresting. In a monograph whose author had described its application as extensive, or both reviewers had been instructed, through whatever channels operated in German academic publishing in 1909, that canon 17 was not a subject for review. I have looked into the channels. The journals in question were both controlled, in their editorial direction, by the same publishing consortium. The consortium's surviving correspondence for 1909 is held in an archive whose access protocols, when I made the application, returned the response that the relevant boxes for that year were not currently available for consultation. The response did not give a reason. It did not give a date by which the boxes might become available. It noted only that the materials were under review. I have learned to recognize the vocabulary. Under review. Withdrawn. Suspended. These are the administrative euphemisms of a system that has decided, at some level above the archivist, that certain questions will not be answered in the lifetime of the person asking. Here is what I have been able to assemble about the application of canon 17, working from sources that have not been suspended, withdrawn, or placed under review. The canon was invoked by tribunals whose proceedings are partially documented on at least 11 occasions between 626 and 1812. The territories in which the invocations occurred form a geographical pattern that, when plotted on a map of medieval and early modern Europe, traces almost exactly the eastern and northeastern frontier of Latin Christendom. The marches, the contested zones, the territories where Roman ecclesiastical authority abutted, overlapped, and competed with the political formations that the chancellery vocabulary of three empires would by the 18th century refer to in their internal correspondence under a single collective designation. The designation does not appear in any published treaty. It appears only in marginalia, in deferral notes, in the instructions ambassadors sent to one another when they wished to discuss a matter that the public diplomatic record was not permitted to acknowledge. The designation, in the surviving fragments I have been able to access, is the Eastern Claim. I'm going to use that phrase carefully because the temptation, when an investigator finds a phrase like that in three independent archives, is to load the phrase with more meaning than the surviving documents support. So let me stay with what the documents say. The Eastern Claim, in the chancellery vocabulary of the Habsburg, Russian Imperial, and Vatican correspondences I have been able to read, refers to a category of dynastic lineages whose territorial sovereignty had been displaced by the partitions, the consolidations, and the rationalizations of the 18th and early 19th centuries, but whose hereditary status had not been formally extinguished by any public act of any successor authority. The lineages, in other words, were politically homeless but legally alive. They had no thrones. They had no chancelleries. They had, however, names. They had registers. They had, in the language of canon law, a continuing baptismal claim. A continuing baptismal claim, in the framework of canon 17, was precisely the kind of claim a determinatio extinctionis was designed to terminate. Ask yourself what kind of legal instrument it is, that sits in the canonical record for nearly 12 centuries, almost never invoked in the heartland territories of Latin Christendom, but invoked repeatedly, quietly, in marches and frontiers against lineages whose political existence has already been displaced, but whose names continue to appear stubbornly in baptismal registers and burial books and the marginalia of provincial cathedral archives. Ask yourself what would have been the alternative for the consolidating authorities of the 18th and 19th centuries if Canon 17 had not existed. The alternative would have been heraldic. The alternative would have been the published declaration in folio editions issued by named publishers that a particular line had ended. The alternative would have produced the document that historians, 2 centuries later, would find in archives, would footnote, would teach. The alternative would have left a trail. Canon 17 does not leave a trail. By its own 73 words, it requires only that the determination be recorded decently. A determination recorded decently is not a published declaration. A determination recorded decently is a single line in a tribunal's internal protocol, kept in a chancery whose successor institutions have, in every case I have tested, placed the relevant centuries under access protocols that remain in force. I tried to find a determination. I want to be precise about that effort, because it failed, and the manner of its failure is part of what I am trying to describe. I applied to 4 ecclesiastical archives whose holdings, according to published finding aids, include the protocols of tribunals that, on the dates and in the locations I had been able to identify from secondary sources, would have ratified determinations under Canon 17. In every case, the application was acknowledged. In every case, the response, after delays ranging from 3 months to 14 months, was substantively the same. The protocols were not currently available for consultation. The relevant series was under review. The volumes had been withdrawn pending an evaluation of access protocols. The evaluation had been initiated in 2 of the 4 cases in years preceding my birth. 4 archives, 3 countries, 4 different access regimes, 4 substantively identical responses, separated in some cases by decades, coordinated by no body that any public document acknowledges exists. Not debated, not disputed, not investigated. What disturbs me most is not the inaccessibility of the protocols. It is the precision of the inaccessibility. The withdrawn volumes are not the volumes for the centuries before Canon 17's most active invocations. They are not the volumes for the centuries after. They are, in every case, the volumes for the windows of years in which the chancellery correspondence of the consolidating empires refers, in its marginalia and its deferral notes, to the Eastern claim. I do not know who decided. I genuinely do not know. I do not know what coordinating authority across 4 ecclesiastical jurisdictions and 3 secular ones determined that the protocols of those particular windows would be the protocols that successor archivists in every generation since would find under review when they reached for them. I do not know whether the determinations recorded decently in those protocols would, if read, name the lineages I think they would name. I do not know whether the consolidations and rationalizations of the 18th and early 19th centuries, the partitions, the absorptions, the quiet disappearances of names from heraldic registers that historians have explained through wars and treaties and natural extinctions, were, in some unrecorded number of cases, the secular ratification of an ecclesiastical determination that had already been made, decently, in a tribunal protocol against a bloodline whose continuing baptismal claim the order of the Christian Commonwealth could no longer accommodate. What I can tell you is that the canon exists, that its language is exact, that its standard is undefined, that its recording requirement is decent, that its invocations cluster, geographically and temporally, in precisely the territories whose dynastic disappearances the chancellery correspondence of 3 empires referred to, in coordination as the management of the Eastern claim, that the protocols which would name the determinations are, in every case I have tested, withdrawn, suspended, or under review. What if the erasure of Tartaria, the disappearance from political maps, from heraldic registers, from the genealogical compendia that should have recorded it, was not primarily a military event? What if the wars and the treaties and the partitions were the visible secular performance of a process whose actual legal mechanism was a 73-word canon adopted in 626, kept dormant for centuries in the Latin acta of a provincial council, and reactivated quietly by tribunals whose protocols are now described as not currently available for consultation, against lineages whose existence the consolidating authorities of Europe had decided the order of the Christian Commonwealth could no longer permit? How many mysterious dynastic extinctions in the centuries between 1750 and 1850 suddenly become legible? If you accept that the legal authority to extinguish a bloodline, recorded decently in protocols that would never be published, had been sitting in the canonical record since the 7th century, available to any tribunal a coordinating authority chose to constitute, the buildings remember, even if the chancelleries do not. The canons preserve, even if the tribunals erased. I have one more thing. In Vossberg's 1908 monograph, in the same paragraph that contains the sentence I have been turning over for 9 months, there is a second sentence I did not, on first reading, fully understand. It reads, "The canon, by the explicit language of its drafters, does not provide for the rescission of a determination once issued. The drafters appear to have considered the determinatio extinctionis a sacramental rather than a juridical act, and sacramental acts, in the framework they inherited, were not subject to subsequent reversal by any successor authority. A determination of extinction, once recorded, could not be undone. Not by a later council, not by a later pope, not by a later tribunal that might, in some hypothetical future, have wished to recognize that a lineage the canon had declared extinct had in fact continued. The decision was sacramental. The recording was decent. The effect was permanent. It feels like a door that someone very carefully closed in 626 and handed the key to a tribunal whose successor institutions have been, ever since, very careful about who is permitted to ask whether the door was opened, and on whom, and how often. Whose names sit in the protocols that 4 archives have, in coordination, kept under review across decades that began before any of us were born? What lineages, declared extinct sacramentally in tribunals whose proceedings the canon required only to be recorded decently, are still, by the framework of the canon's own drafters, legally extinct in the eyes of an institution that has never repealed the 73 words that authorized the extinction? And in the marches, in the frontiers, in the territories whose names the chancellery correspondents of 3 empires agreed quietly. To call the Eastern claim, how many bloodlines were ended not by the sword and not by the treaty, but by a single line in a tribunal protocol, written decently, in a hand that knew the line would never be read by anyone whose reading could undo it?